off of the children's book that I cannot remember the name of, but You Can Too is in there. So I decided it sounded good to be the name of my presentation. So today I'm going to be talking to you about the Escazu Agreement. I'm going to try not to make it too heavy because, if you're not interested in the information, you're not going to engage in it, you're not going to absorb it so that it can be useful to you. So our journey, the first step in our journey is telling you what the Escazu Agreement and taking you through the pillars of the Escazu Agreement. Then I will tell you how the government of Antigua and Barbuda is implementing the Escazu Agreement. Then I'm going to tell you how the Escazu Agreement is relevant to your work as testing. Hello? Better? Okay. Relevant to your work as NGOs, as CSOs, and I believe we do have some government agencies here as well, so it is relevant to them. And then I'm going to talk about, additional tools that you need with the Escazu Agreement to help make your environmental advocacy more effective. So, first step in our journey is give me the SUS. What is the Escazu Agreement? So the Escazu Agreement, before the Escazu Agreement, there was Rio plus 20. So there was a UN conference on sustainable development in 2012, and Latin American and Caribbean countries, who are usually at the forefront of discussions about environmental justice and environmental defenders, they signed the declaration on the application of Principle 10 of the Rio Declaration on Environment and Development. So in this declaration, the government, in this declaration, the government stated that they need to reiterate Principle 10 of the Rio Convention. Principle 10 states that environmental issues are best handled with participation of all concerned citizens at the relevant level. So by all concerned citizens, it is a very broad definition of what a concerned citizen is. It includes natural persons, it includes NGOs, it includes organizations, it includes even persons who are not living in the area that is directly affected by the environment. So after the adoption of this declaration, but before the agreement was actually signed and ratified, they had a negotiating process. So this negotiating process, 24 countries came together, and y'all know how group work goes. This took 2 years, and there were 8 iterations of the Escazu Agreement before we got the final version. So this, again, it took 4 years for this negotiation to be concluded, and then we had the Escazu Agreement. So the Escazu Agreement was finally adopted in March of 2018, and it was entered into force on the 22nd of April 2021. Antigua and Barbuda was one of the first signatories on the 29th of September 2018, and we ratified the agreement on the 4th of March in 2020. So the basics of the Escazu Agreement, this is just a broad scope of what the agreement entails. It is the only treaty in the world with specific provisions for protection on human rights defenders in environmental matters. It establishes legally binding obligations for state parties to adhere to. It links human rights in the environment, and there are 5 main environmental principles that are included in the Escazu Agreement. So there is, in regular treaties, there's a preamble, there's a definition section. I'm not going to take you through that because, I'm not going to take you through that point by point because that's going to turn into a law lecture and it's going to be very boring for you. So I'm going to take you through the 5 main pillars, and while I'm taking you through the pillars, I'm going to talk about the duties that the government must be held accountable for under these 5 environmental pillars. Just as a point of note, the Escazu Agreement is all about accessibility to environmental information. And so every session, every meeting, even negotiations, the negotiations for the actual environmental agreement were broadcasted live so that the public could have access to them. They were broadcasted in the 6 UN languages for people to have access to them. They were broadcasted with captions, with everything that is needed for persons, especially persons with disabilities, to access. So the first pillar of the Escazu Agreement is access to environmental information. And so this is found in Articles 5 and 6 of the Convention. And there is a duty on the government of Antigua and Barbuda to provide access about the environment. And so they must do this in a way that the public has easy access to this information, whether it be on a website or whether they are able to call and say, okay, I'm coming in to look at this document, I'm coming in to look at this policy, I need access to it. And when you ask for access to this information, they're not supposed to ask you why. So if you go in and say, well, I want this document because I want them, that's it. They can't ask you for any other reason why you want the document. The second duty is that there must be a quick response to access. Now, I know what it's like emailing a government agency. I know sometimes, they just don't answer. But they are supposed to answer, and one of the pillars is that they're supposed to answer, give you this information within a reasonable time. And this is underscored in all of the pillars because if you are to participate in environmental decision making, you must have access to this information in a timely fashion. So if they're supposed to be having a public consultation and you need access to the document 2 weeks beforehand, you need to be able to have access to this document. They're not supposed to drag their feet. They get a document the day before. It's 350 pages. You can't analyze it. You can't assess it, so you can't go and make accurate representation at this consultation. If there is a cost associated with access to this information, for example, if they have to print it or reproduce it, if it's a document that they only have the PDF for and they have to print it, then in cases where a person, wants access to the physical copies of this document, they're supposed to either waive or reduce the costs of producing this information. So if they have to print it at government printer and it costs $60, they're not supposed to charge you the full $60. Public participation in the environmental decision-making process. So this pillar states that government agencies must provide avenues for public participation in decisions made about the environment. Later on in the presentation, I'm going to show you how this is actually, the language of Escazu is actually replicated in several pieces of legislation in Antigua, pre-Escazu and post-Escazu, so you understand fully that there are avenues, there are mechanisms in place for you to advocate for your rights based on the Escazu Agreement. So the government is supposed to provide avenues for public participation in decision making. And again, like I said, this includes providing the information in a timely fashion so that people can understand and absorb the information. The government is also supposed to identify specific sectors of the country that are going to be most affected by activities taking place in the environment. So they're supposed to, if they're going to be doing a large-scale development or anything that's going to affect the environment, they are supposed to identify the possible vulnerable stakeholders in the area that are going to be most affected by this decision. Y'all still with me? Y'all very quiet. Okay, great. Okay. I'm just that interesting that y'all so quiet? That's great, that's great, that's great. Okay. So the next pillar probably, did I go back? There we go. Okay, the next pillar is access to justice in environmental matters. So the government is supposed to ensure that the public has the right to challenge and appeal decisions, actions, or omissions made in activities related to the environment. And they're supposed to have create entities that are competent about environmental matters. So just going back again, I'm going to detail all of the actual avenues that we do have in Antigua, the existing avenues we have in Antigua for persons to challenge decisions made about the environment. They're supposed to be transparent decision-making processes, so they're supposed to detail how they came to this conclusion. And they're supposed to ensure that there is broad legal standing for persons to challenge decisions made about the environment. So legal standing just basically means that you have a right to bring the suit before a court. So ordinarily, to ensure that a court is not inundated with frivolous lawsuits, they will say, okay, you don't have the right to bring this case because this doesn't affect you. This does not concern you. you're just causing mischief. However, in matters related to the environment, government agencies are required to ensure that everybody in the whole of Antigua and Barbuda has broad legal standing to bring cases before a competent court about decisions related to the environment. So that means if there is a development, say on Redonda, it's just an example, Shanna, don't look at me like that. If there is a consultation, or if there's a decision made about a development in Redonda to put, lights on Redonda, for example. Even nobody here lives on Redonda, and the king is not in here. So the king would not be the only one that would be able to have a right to bring a challenge to this decision before the court. Everybody in this room would be able to say, that don't make no sense. Why are you bothering the lizards? Why are you bothering the birds? Everybody should be able to bring this challenge before the court. So this pillar is human rights defenders in environmental matters. So while we don't have examples of the extreme violence that is meted out to environmental defenders in certain Latin American countries where environmental defenders are actually murdered, turn up missing, or otherwise exposed to violence, we do have the duty to guarantee a safe and enabling environment for human rights defenders in environmental matters. So that means everybody should be able to, without fear or favor, make known their concerns about the environment without worrying about any sort of backlash or violence or assault. And in the case where such any backlash or violence or assault occurs, the government has the duty to investigate these threats and make arrests and do prosecution for any harassment that is meted out towards human rights defenders. The last pillar is capacity building and cooperation. So the government has the duty to set priorities for capacity building and cooperation, not only amongst other government agencies, but for CSOs and NGOs, to ensure that they have accurate training to advocate properly and engage properly on environmental matters. So this could be doing public awareness campaigns, having scholarships, doing education for people to understand so they can properly understand environmental issues. And also, they have the duty to train the public and government authorities on how to properly investigate and mediate on matters related to the environment. So before I move on, I like to do piece of questions, because sometimes, I don't know about y'all, but when I'm listening to a longer presentation, I forget a question that I have from the section. So if anybody has any questions about the pillars of the Escazu agreement, feel free to ask them. I'll take 2 questions. Yes.
With what?
Yeah.
I've got the mic. With what you were just saying about training, who's providing the training for the public?
So if the government has the capacity to provide the training, then they should provide the training. If they do not have the capacity to provide the training, they should hire people to provide the training or create avenues for people to access this training.
Who does that hiring, the government or the person who's needing the training? Who does the hiring of the capacity to train the people? Is that the people wanting the training or the government on the behalf of the citizens?
The government, because this is the duties of state parties.
Okay. Thank you. I could go on maybe at a conversation later.
Rulio has a question.
I'm giving you early warning. This won't be my last question throughout the presentation.
I know.
But because you're going to move on to how Antigua implements it, I have a question here as it relates to environmental protests. And how does the Escazu agreement relate to environmental protests? Because currently, worldwide, you're hearing a lot of things about environmental protests and people getting arrested and that kind of thing. So is there any kind of linkage between those two? Am I making sense?
Yeah, there's absolutely a linkage. And I think it's going to be, I'll expand on it more in the what I do part of the presentation. So, but that's a very good question, and it does come up. I think Shanna had a question, and this is the last question, so I can move on.
I think it was in Article 8, or was it 7? The one before, yes. So this one that speaks specifically about challenging and appealing decisions made about the environment. Can you go into some more detail about that? Because let's say hypothetically that there is a development happening on an island where there's the largest amount of Antiguan racers on the planet, right? And there's a restaurant that is being built on there. That it's hypothetical, has been built on there after you have invested $250,000 over the past 20 years and you have just eradicated rats from it for the 4th time. Once that restaurant is up in the priority area for the snakes, what can you do at that point once the damage has been done?
Okay, that's also a very good hypothetical question that is answered in the next part of my presentation. Right. So, as I stated, there are pre and post Escazu legislation that exists in Antigua that does address all of the concerns that you guys are having, especially as it relates to challenging decisions made. There are some gaps, and the Department of Environment recognizes that there are some gaps, and we are working to fix it, and I'll go into that a bit later. But the most government agencies are considered the duty bearers of the Escazu Agreement, which means most of the provisions that are in that agreement are talking to what we should be doing, and explaining in very explicit detail how we should be doing it. So I know y'all tired of hearing me talk about the Environmental Protection and Management Act, but there was a lot of work that went into this, 5 years. I'm not going to stop talking about it. So, so the language of the Escazu Agreement is actually intertwined throughout the Environmental Protection and Management Act. So just to give, there's some clips here that I took just out of the objectives of the Act, of the Environmental Protection and Management Act. One of them is to promote and encourage among all persons a better understanding and appreciation of the environment. This one, protection of the environment for present and future generations, is a phrase that is littered throughout the Escazu Agreement. It speaks about present and future generation. It doesn't only talk about the now. Public awareness regarding the state of the environment, public participation in and transparency of the decision-making processes regarding environmental protection, access to justice in environmental matters. So that's just in the objectives of the legislation. So I spoke about the duty to provide access to information. We have in Section 24, for example, a register of the sources of pollution, which is a specific duty that is called upon in the Escazu Agreement. We have in Section 29, which speaks that there should be consideration of any objections or appeals made by the public in choosing to grant a pollution permit. In Section 43, which speaks to our favorite thing, EIAs, which says that the department must post and make available an EIA for the public to access so that they can read it. Should be noted, however, that if any decisions that are made about the development of the environment are not made by the Department of Environment. We came after the DCA, so we provide the advisory. So even if we have an environmental impact assessment and we review it and we say, nah, this is actually crap, the DCA can be like, well, okay, and continue to approve it. And therein lies your avenue for appeal. Again, note the appeal would lie under the Physical Planning Act, not the Environmental Protection and Management Act. And Section 44 of the EPMA says you want to appeal a decision about a development which uses an EIA, look in the Physical Planning Act. It's right there. I'll go into the Physical Planning Act as well. Section 86 speaks about the natural resources inventory, which says that the Department of Environment is supposed to make available information about the environment. Now, I don't have to tell y'all that this takes a lot of work, a lot of data collection. We are still trying. We depend on CSOs, we depend on NGOs, we depend on people coming from overseas to come and study specific biodiversity in Antigua and Barbuda, and they provide us with this data, all of which is made available on our IMAS. So shout out to Aaliyah from the DMU. She can tell you all about the IMAS and all the information that's on there. But all the information that we have collected so far about the natural resources inventory resides on the IMAS. Section 87 speaks about an environment registry where we are supposed to upload documents that have been submitted to the DOE for consideration. This includes EIAs, this includes policies, this includes any document that we would have asked consultants to write about a state of environment, about management procedures, about management plans, about management policies. All of that is supposed to exist on our environment registry, which is currently under construction because, again, that takes a lot of work. Section 106, so I know I spoke to you about broad legal standing. Section 106 of the Environmental Protection and Management Act gives standing for persons to bring actions against any person who they reasonably suspect is responsible for a violation under the legislation. Do you need me to kind of break that down a little bit more? Yes? Okay. All right, so let's use the Redonda example again, the real hypothetical example. So if it is that, there is a development taking place on Redonda and Shanna thinks that these persons are violating the birds, they're disturbing the natural habitat of the birds, Redonda is supposed to be a protected area, she can bring that person to court. She doesn't have to go through the government. She can take her own private decision if Shanna is flush with money like that and be like, I'm taking you. I'm going to talk about that too. Don't worry. I'm going to talk about that as well. I know. So yes, Shanna would be able to, in her private capacity, take the developer on Redonda to court for disturbing the birds. Is that clearer? Yeah? Yeah? Okay. So Section 108 speaks about the rights for a person to sue and recover compensation for offenses under this act. So if somebody, let's see, there's a section under our legislation that has an offense for discharges to the atmosphere of a pollutant that is irritating or it makes you sick. You would be able to take that person to court for disturbing your peace, for perplexing your tranquility, and of course for whatever health concerns arise thereafter. You are able to do that without coming to the government to do that. Again, Section 115 of the EPMA speaks about the provision of training, the provision of research, and the provision of education on environmental issues to NGOs, CSOs, and relevant agencies. Section 116 requires the department to develop programs for public information and public awareness. Section 119 speaks about appeals to the minister, who must communicate this complaint or this appeal to a committee, so he doesn't make the decision by himself. And if the person is unhappy with a decision made by the appeals committee, then they have leave to take it to the court. And Section 120 also speaks to public comment and procedures. So if the Department of Environment, when we put out notices in the paper, for example, we've put out a notice in the paper for an intention to declare Redonda as a protected area, we have to adhere to this public comment and procedure and leave a period open for public to make representations, objections, to us declaring Redonda as a protected area. I noticed we didn't get any. Thank you so much. Okay, so the next piece of legislation that provides avenue to access information comes 10 years before the Escazu Agreement, and it's the Freedom of Information Act. I don't know how many of y'all are familiar with the Freedom of Information Act, but it's actually a very thorough and useful piece of legislation. So as you can see, it's supposed to promote maximum disclosure of information in the public interest to guarantee and facilitate the right of access to information and to provide for effective mechanism to secure this right. So this is another avenue by which you can request information. If it is that you request information from a specific government agency and they don't answer you, then you may make that request to the Information Commissioner and state that this agency did not answer my request for information. And the Information Commissioner is then supposed to follow up on this complaint, ask the agency, what's going on? Why never send the information? And they're supposed to they can make a direction to the agency to provide you with the information. So the Freedom of Information Act also makes a nod to the Constitution of Antigua and Barbuda, and within the broad objectives of Section 12 of the Constitution, every person has the right and is free to receive and disseminate information and ideas without interference. So we can use this broadly to interpret that means it's a right to access to environmental information, and a subtle but not really specific right for environmental defenders to request this information and speak without fear or favor. So the paramount purpose of this act is to give maximum effect to the right in respect of information held by public authorities. And within this act, there are some exceptions. There are some exceptions for like public security, whether or not the releasing of the information would be against the public good, or if this is classified information. So there are some exceptions to the right to request information. But if there is a refusal by the Information Commissioner to provide this information, they have to state clearly the reason why in writing. So they can't just say, well, I don't want to give you that. They have to state why, and they have to cite that it is because of these reasons. It's an exception to the right to access this information. Section 15 of the Freedom of Information Act speaks about the right of access. So notwithstanding any law to the contrary and subject to the provisions of this act, every person has the right to obtain on request access to information. So again, this was passed in 2004. This is pre-Escazu. And this is pre the Environmental Protection and Management Act. So these avenues already exist for you to have access to environmental information. Again, as I stated, we are aware that there are some gaps in the legislation, and there are existing gaps in other legislation that doesn't have to do with the Department of Environment. So while the Constitution speaks about freedom of expression and the protection of right to life, this speaks to the right of environmental defenders to speak without fearing for their lives, and the freedom of expression, again, the right to speak without fear or favor. We also have the Ombudsman Act. Everybody knows what the Ombudsman is? Yes? No? Okay, well, Dr. Marion Blair is our Ombudsman. And the Ombudsman is supposed to investigate any complaints related to decisions, omissions made by a government agency. So their office, I believe, is located in Jasmine Court. They have a very useful website. That is another avenue by which you can access justice, in that if a government agency refuses to give you information, you can make a complaint to the Ombudsman, and they are supposed to action it. There is a very handy flowchart on the Ombudsman website which details the procedure. What happens after you make a complaint? Who does the Ombudsman speak to? So the Ombudsman will speak to the permanent secretary or the minister, and that person is supposed to take action. And the Ombudsman is supposed to provide feedback on what happens to your complaint. So there's this avenue for accessing environmental information if you don't get it from the relevant agency. I spoke about the Freedom of Information Act, and I spoke about the Physical Planning Act. Again, just to reiterate, the Development Control Authority is the agency that is in charge of making any decisions related to the development of Antigua and Barbuda. So any appeal that would lie against the development would be against the Development Control Authority. The governing legislation of the DCA is the Physical Planning Act, and within this act, there lies an appeals procedure which is detailed, which speaks about making an appeal against a decision made by the Chief Town and Country Planner. It also sets out what you're supposed to include in this complaint, say why you think that this decision should be made, can cite whatever studies you have. If you have an EIA that states that this development as is would do irreparable harm to the environment, or you can even make an appeal against the decision to let a development continue because this is doing irreparable harm, or that the person is not adhering to the provisions in the EIA. Is that clear? Or do I need to go over that again? No? Clear? Okay. So government agencies that sometimes do make decisions about the environment that are not governed by the Environmental Protection and Management Act would be governed by these other pieces of legislation that I would have cited. So the Constitution, the Ombudsman Act, the Freedom of Information Act, and the Physical Planning Act for DCA. So some of these agencies like the Plant Protection Unit, Agriculture, Fisheries, Forestry, Department of Marine Services and Merchant Shipping, those other agencies, if they don't have specific appeals in their legislation or provision of access to this information, you can make an application under any of those pieces of legislation that I would have cited. So some of the other weaknesses that we would have identified in the existing legislation is the absence of specific legal standing for environmental defenders to bring matters before the court. So even though the EPMA does say that you can take this to court, the legislation is not specific enough that it provides this right irrevocably. Somebody could argue that you don't really have the standing to bring this before the court. So that is a gap that we've identified. Another gap we've identified is the absence of specific legal protections for environmental defenders. So while we can read things into statute that already exists, again, for example, under the Offenses Against the Persons Act, you're not supposed to go and interfere with somebody if they're saying something that you don't like. There's no specific legal protection that speaks about interfering with an environmental defender in their course of protecting the environment. So this sends, and it is of the opinion that from the parties of the Escazu agreement, that this sends a stronger message that you are not to interfere with environmental defenders if you spell it out specifically in legislation that you're not supposed to do it. And the last gap that we've identified is the high cost of environmental litigators, the high cost of hiring a lawyer to take this person to court. And I would have made an allusion to whether or not Shanna was flush with cash, because we do know that, speaking as a lawyer, I do know that the fees for litigation are quite high. So what the Department of Environment is actually doing is that we have drafted, with the help of a consultant who is very knowledgeable in environmental justice matters, we've drafted an amendment and regulations to our Environmental Protection and Management Act that specifically detail these rights. Can't share that with you yet because it's currently under review at Legal Affairs, so I can't disseminate it yet, but there will be a public consultation for people to be able to give their feedback on this amendment and these regulations. So in the amendment, we've included a definition for environmental defenders, for environmental decision making, for natural resources. We've included specific protections for environmental defenders. which makes it an offense to interfere with them in the course of their advocacy. And we also have included a right for an environmental defender if they have been interfered with and they have to expend any money for like security, or they have to expend any money for any trauma that is associated with them being assaulted, they can take the perpetrator to court and recover those costs in a civil claim. The regulation speaks about the register of environmental mediators, because nobody wants to spend 3 years in court over a matter. And mediation is the preferred method. More judges are moving towards mediation, where both parties sit down at a table and they try and talk out the issues and try and come up with a solution. So we are supposed to come up with a list of environmental mediators. And the regulations also mandate that the legal aid and advice clinic, I'm not sure if anybody else, how many people are familiar with the legal aid and advice clinic and legal aid and advice center. It is a legal office run by the government of Antigua and Barbuda, which provides low-cost legal advice and legal services. So they do the services at a much reduced cost. However, we have to create the capacity within the legal aid center for them to handle environmental matters. And we also have to have a discussion whereby the person suing might be suing the government. Like, what do we do in that situation? We also have within the regulations that the Bar Association will be responsible for trying to find a person who will do this work, either pro bono or at a much reduced cost. So we didn't have these discussions in a vacuum. We met with stakeholders. So we met with the Legal Aid and Advice Center, and we did meet with the Bar Association so that we could discuss these matters. Y'all bored? No. Okay, great. Y'all just quiet. Okay, so Escazu and you. I don't think I have to go into too much detail about why this is relevant to your work, because y'all know why this is relevant to your work, but I'm going to do it anyway. CSOs and NGOs are considered the rights holders under the Escazu Agreement. This means, and we have, within the Escazu Agreement, they've explained who they consider rights holders, and you will notice the first one is every person of present and future generations. So I'm sure you've heard Greta Thunberg talking about, oh, you are spoiling the environment for me and my generation. What happens to the next generation? This is included in the within the Escazu Agreement. It speaks about the public, persons and groups in vulnerable situations. So persons and groups in vulnerable situations means persons who, by virtue of whatever circumstances they are in, whether it be by poverty or illiteracy or digital illiteracy or disability, or whether or not they're housed, those persons are persons in vulnerable situations. And the Escazu Agreement states that state parties must provide specialized access to these persons. If they're not literate, you must sit down with them and go through the document. If they can't afford to buy the document, you have to give them the document for free or at a reduced cost. If they can't afford if they can't afford the costs of a lawyer, you have to provide that at a reduced cost, because this is the only way that you're going to be able to provide justice to them. So persons, associations, organizations, or groups that promote environmental protections. It speaks broadly about an applicant, public directly affected, and human rights defenders in environmental matters, and indigenous people and local communities. So as you can see, rights holders are given a very broad definition so that everybody has access to environmental justice. So some of these rights are right to guidance and assistance from the duty bearers or the government, the right to access environmental information. As you can see, I'm just repeating the pillars, right? The right to participate in decisions made about the environment, the right to capacity building, the right to a healthy environment. Let me tell you, that is such a touchy issue at the convention level, the right to a healthy environment. You wouldn't believe the people that are arguing against that. Anyway, we won't talk about that. And the right to speak without fear and harassment. So Escazu it's a tool for environmental justice. And what this means is that it's providing the avenue, or it's providing the information for the public, for civil service organizations, for NGOs to access environmental justice, whether this means access to information or access to legal representation. So the Escazu Agreement promotes the role of the public in environmental democracy because it is recalling Principle 10, which I would have said that, the state believes that the only way to have proper discussions about the environment is if the public is able to participate at every level. It provides a tool for holding government agencies accountable. Again, these tools existed in prior legislation, but this kind of just recalls that the government has a duty to provide the rights that are outlined in the Escazu Agreement. It provides an avenue for the public to have a say in decision-making as it relates to the environment. It provides an avenue for the public to request access for information. It provides protection for human rights defenders on environmental matters. And it also speaks about the provision of resources to governments, NGOs, sectors, and CSOs for the implementation of environmental strategies, policies, and programs. Because the Escazu Agreement is a legally binding agreement, these provisions, these rights, these duties are absolute. Like, there is a legal obligation of the government to provide these things. So the last section of my presentation speaks about the other tools that you need. The first and most effective tool, in my opinion, is community. So one of the markers of a successful environmental advocacy is I scratch your back, you scratch my back. So if one agency has expertise in environmental management and monitoring, or if one agency has expertise in public consultation or galvanizing support behind a specific issue, then these agencies, if they don't exist, these things don't exist in the same agency, then you need to work together. If one agency has grant writing skills and another agency has the skills to successfully pull off a project, then the agency with the grant making skills should be providing training to the agency with the skills to pull off a project. And it's not I'll do it for you. I'll show you how to do it, then you can do it yourself. And in that way, everybody grows when you're sharing this information, when you're sharing the skills that you have. The other tool that you need is knowledge. So I know y'all know, I know a lot of people in this room know that they can call me when they have a question about the Environmental Protection and Management Act, or they can email me. And even if I respond in 5 days, I'm gonna respond. I'm gonna send you a 3-page email. I'm gonna say, if you have any questions, feel free to call me or email me again, and I'm gonna email you, I'm gonna answer you. But this information, this knowledge is one of the keys to successful environmental advocacy. There are a lot of people who don't know about these avenues or these avenues to access environmental information. And because they don't know, they think that the most effective way, not knocking any specific way about raising awareness, they think the only way to get access to justice is to just make noise. You have to make noise strategically. And making noise strategically means utilizing legislation that is in place. The legislation exists and it's there for people to use it. So those are the two tools I think civil service organizations and NGOs need, along with the Escazu Agreement and along with the provisions in the Escazu Agreement to have effective environmental advocacy. And thank you.
Since everybody's nervous, thank you for such a wonderful explanation, Anika. I think the breakdown was really helpful, and I'm actually quite looking forward to the amendment that you referenced. You touched on a point about there's still a gap as you think about potentially if you're taking the government to hand. And I just wonder if like if someone was thinking about it from that angle, what would be your advice to them or recommendation? Because there are scenarios where the party that you'd think about taking to hand is the government. So how would one go about that or think about that kind of approach?
Thank you for that question. Well, in that instance, it was fully conceived, which is why we had the Bar Association as a stakeholder. This is bringing awareness to attorneys in Antigua and Barbuda that, hey, there are groups, there are interest groups or interested persons who are interested in bringing some sort of action against the government as the party, and that in this instance they should provide either pro bono or reduce services or provide a payment plan. And this, I want to say that this is something that, you know, you're required to provide as an attorney. Not required legally, but they do say, hey, you know, if you can, do some pro bono work, you know, and that pro bono work, if attorneys are aware that there are environmental matters, they can say, hey, well, we're not allowed to advertise it, but they can say, hey, I also do cases as it relates to the environment. So it's really dependent on the goodwill of those persons that are called to the bar in Antigua and Barbuda. Maybe not the young, struggling lawyers, because they don't have no latitude, they don't have no money to do no pro bono work. They really have to be grinding really hard so they don't have to eat crackers and cheese every night. So one of them older attorneys who have been called to the bar for 50-something years, they don't have their money. All they do is probate cases, and they just sit down. One of those people, those are the people who should be interested. And we're really trying to get these attorneys, or all attorneys, more interested in environmental advocacy through litigation. So that's something that public awareness, that we do need to do more public awareness on.
So I have a question for you. It's a wonderful question.
I bet it is.
So in your presentation, you referenced the Development Control Authority, and you were very clear to say that they have the final say in terms of decisions for development. It's not something that we can pong down the door at DOE for. However, the Environment Protection Management Act gives DOE the mandate to protect, conserve, and safeguard and maintain natural ecosystems. So since DOE has that mandate, and protecting natural ecosystems from developments that may be harmful would then fall under that mandate, what is being done to sort of plug that gap that exists between what DCA does and what DOE is mandated to do in terms of environmental protection, and how can we possibly through an amendment to the EPMA or even an amendment to the Physical Planning Act ensure that DCA can't just get up and say, oh, even though DOE has found gaps in the environment impact assessment, we're going to go ahead and approve this development anyway, even though it's going to knock down half of Redonda hypothetically. So what is being done by DOE to ensure that we can plug those gaps, as well as to dissuade DCA from taking the steps to approve developments that are potentially harmful for us?
Woo. It's a very good question, and probably the reason for the 12 gray hairs in front of my head. Exploring an amendment. We have explored an amendment to the Physical Planning Act, and we have explored said amendment to the EPMA, but there is no, trying to find a sensitive way to say it. The will is not there. And I'm not just political will either. When we have public consultations, people do not come. They prefer to go on social media or the radio, and they talk about it there, but it cannot stop there. You have to do that in conjunction with attending these public consultations and making your voice heard. It is long, arduous work. I've spoken to environmental defenders from Latin American countries, and they talk about this in 100 letter, 200 letter, 300 letter. It is continuous work, and until we are really held accountable and not on something that we can easily lock off and relegate to background noise, nothing is going to change. Going to be honest. We have expressed, we do work closely with DCA. They sit on our technical advisory committee. The Department of Environment sits on the physical planning committee. There's a physical planning committee that speaks about that discusses the applications. And as much advocacy that is done there, at the end of the day, they tell us, go on, and the issue becomes a shooting star, it burns bright and then goes about its business, then nothing is going to be done. So the solution is to hold fire under the government foot. Hold us accountable. Continue making noise in the avenues that I provided for you. Continue making noise, yes, on social media, but also in using the tools that is in our legislation. So we can talk till we blue in the face, and trust me, we've sent emails, we've gone on the site visits and say, this don't make no sense. And at the end of the day, unless somebody's continuously making noise, nothing is going to happen. So I hope that answers your question. Does that answer your question? No? I heard somebody say no. What else is unclear? Exactly. Somebody else said no. Yes?
Related to that question, and I thank the lady for asking it, because it's the elephant in the room.
Mm-hmm.
From my observation and experience, DCA is a non-functioning, corrupted and perverted agency. And I know those are strong words. I know they're strong
They don't
words.
hurt me.
And I welcome the Escazu agreement. There is a Form 14 of the Physical Planning Act, which very few people are even aware exists. And it is the common practice for DCA to ignore the existence of that. I wrote to DCA because apparently you need to seek permission in writing for any of the documents that are public documents in the registry, when that isn't actually the case. The legislation, as I understand it, 72, and I think it's C, says any member of the public can go into DCA and for the appropriate fee have a copy of any document on the registry. Am I correct in that understanding?
Yes.
So I sent a letter.
There's just to say that once you're paying a fee, that there is the presumption that you're submitting an application.
I understand that, but I'm trying to get copies of developments that affect me and people who have shared interests. And this Form 14 is an extraordinarily important omission of DCA, of an act from 2003. That's 20 years ago. And I have only ever seen one Form 14. And if you think about it, Form 14 would save an awful lot of grief for all of us. Anyway, back to my request in writing of about 20 different projects. That request has not been fulfilled. The day that I was meant to go and view them, not get copies, I had a call saying, oh, we're having difficulty compiling it all. It's postponed. When I asked for when will it happen, we don't know. There is an active political, I would suggest, movement within our development procedures that stymies all the wonderful information that you have imparted. And it unfortunately makes a complete anathema of the Department of Environment. I'll stick with the EIDA project. The environmental impact assessment repeatedly said this is not to be used for permitting purposes. Yet the DCA accepted it as a document, and the DCA was given permission by Cabinet to give EIDA permission to go ahead. And EIDA has done whatever he want for do. And as far as I am concerned, and I'm sure people will share that with me, it was an act of ecocide on behalf of the government of Antigua and Barbuda. That is one of way too many cases. And we could go on, but I don't want to bore people. Our development process is flawed for 2023. And I invite you to have a look at a complaint to the Ombudsman, because you mentioned the Ombudsman, for the removal of 85 mahogany trees on the site that is on the Parliament building today. The Ombudsman is also a functioning, non-functioning agency, because I took a complaint to the Ombudsman about the EDA, and when I hear nothing yet from them, and that was in 2016. So all that you say is really encouraging, but you got to be strong to carry this through, because I'm tired.
I would love that same advice right back at you. You have to keep going.
Why should I keep going as a citizen?
But that's why I highlighted the work of environmental defenders in other countries. They're sending 200, 300 requests. They're not letting it rest. I'm not saying this to absolve the government of any responsibility for the development or absolve the government of their responsibility to protect the environment. There are technicians inside these agencies that are trying, but again, we need help from the public, and this is why these avenues are have been created and enshrined in legislation, in different pieces of legislation. So if the Ombudsman doesn't work, you go to the Information Commissioner next. Yes, the Minister of Information is the Information Commissioner. Mm-hmm. Mm-hmm. Thank you.
Okay, I just had a comment about, it's over here. Hello?
Oh.
I'm like a ghost. I'm just floating around. I just had a thank you for your talk, and it seems like the Escazu agreement, you did a lot of work there, you and the other group that were involved, and there's been a lot of progress on the laws. It's great to have those laws on the books. But as we all know, having the laws on the books and enforcing them are two different things. And I think, so the other side of having the laws there, which, you know, is fantastic, the other side of that is it's always a balance of forces. Whether the community versus the developers is going to win is a question of how strong each side is. And whether the law comes into that, but the law can only be enforced if there's a strong community voice against whatever development there is that's planned. And so people like Greta Thunberg, who you've referenced, she's strong in her own individual voice, but her strength mainly comes from the movement that she's set up. So in order to enforce our laws that we have now through the Escazu, we need a strong community movement that's, you know, about protecting the environment and that's prepared to do things not only like write letters, but to come out and, you know, demonstrate in the street, demonstrate at the site where they're trying to put the development in, etc., things like that. And that may seem a long way off, but it's certainly possible. The other thing that I want to mention is that in many places around the world, in Australia where I'm from, the unions are one of your best sources of protection. So if you can get a community movement together, which then the union can say, well, we feel there's enough people here that we can step in as well and say, none of our members will work on that site. They're trying to do development. We're going to prevent our members from, we're going to put a green ban on that site and prevent our members from doing any work on that site. That development's not going to go ahead. And that's your strongest weapon you have in terms of environmental protection. There's a site in the middle of Sydney right now called Shepherd's Bush, which is a green site, a green park area which was saved by the unions in the 70s through a green ban. It's still there today. So just to add a little bit extra there, don't stay in your silos in terms of protecting the environment. Use the legal forces that you have, whatever you can, but look to your strongest weapons, your community involvement and your unions. Thanks.
Thank you for that comment.
Okay, thank you. Question and a comment. Now, it's very interesting interesting for me that the Escazu is being highlighted in terms of the rights and opportunities that it gives the ordinary person to challenge government with regards to what they do. My question is, how effective is it at this stage in Antigua and Barbuda? And the reason I ask that question is because presently, the DCA, with regards to the Physical Planning Act, has a matter before the Privy Council with regards to a particular project taken by me as an ordinary citizen. Now, the main question that's going to be asked and a ruling handed down on in November when the matter comes up is the question of standing. And the attorneys for the government representing DCA is saying that me as the ordinary person is considered to be a busybody. It's none of your business what the project is doing with regards to affecting me, and so you do not have any standing to challenge government with regards to what they decide to do policy-wise. Now that runs contrary to everything that Escazu is about. What gives there? How is this going to proceed? Because come November and that ruling is handed down at the Privy Council against me as the ordinary citizen, it sets the precedence now that every environmental group, every community, every individual, they now will be burdened with that ruling with regards to being able to challenge on environmental matters, which is what Escazu is all about. So where do we go from here?
As it relates to the effectiveness, it was entered into force on March 2020. We haven't tested the effectiveness of the Escazu agreement yet, to be honest. It is legally binding on state actors in Latin America and the Caribbean only. So if you're bringing this case in a jurisdiction, in one of these jurisdictions, if you're bringing it here, yes, but if it's being heard in the Privy Council, it's not legally binding on the Privy Council. It's not legally binding in the UK. It's not legal. Mm-hmm. Oh, actually, you want to hold this question because there was a question over here. So yeah, the effectiveness of the Escazu agreement hasn't been tested yet. I would love for it to see it be tested. I really would, since it is a legally binding agreement. And until such time, I wouldn't be able to make an effective analysis on how strong it is. We are going to continue to do the public education so that people are aware of their rights that they hold under the Escazu agreement. And it would be up to the community to show us how effective it is, whether or not the gaps that we are seeking to address have actually been effectively addressed in the legislation when we do the amendment and we do the regulation. So I would love to see, I would really, really love for somebody to test out the Escazu agreement and to see how that would work. And, you know, you're going to provide us with that opportunity. That would be great. There was a gentleman over here.
Yeah, I was just going to make a quick comment. Read the Privy Council statement. The Privy Council is bound by the laws of the country whose case is coming before it. So if Antigua is a signatory to Escazu and we've ratified, and we are bound to have broad standing. So that's something that the attorneys in that case need to reference when it gets to Privy Council, because it covers.
If I don't think they've amended the claim to include. They would have amended the claim to include the Escazu stuff, because I think this is a long-standing matter before the Escazu agreement came into force.
Well, that might be something that
the
attorneys could look into to do a late amended statement of claim and then amended skeleton, stuff like that.
All right. Good afternoon again, everyone. I'm normally on the shy side, but I'm going to speak at this moment. You know, as I sit here and I listen, it's quite heart breaking listening to some of the challenges and the questions that are asked here today. And I can only ponder and wonder to myself, what type of world, what type of society, what kind of communities are we living in today? I don't understand the reason why these challenges, we are faced with them. Because we as human beings, we live in here, you can say Antigua and Barbuda is our habitat or our domains. And I think that between ourselves and the government, we should all be singing off of the same hymn sheet. All right? And I can't see that if I care about my environment and I am passionate about my environment, why isn't government on the same, why aren't we all not together with this? So I'm saying all that to say is that why are individuals being put in a position to consult with attorneys to take matters to court? Now, I don't want to be political at all, but we just came out of elections. And I do agree, right? Nobody's told me. I do agree that there are elephants in this room, but there are lots more than elephants, because hippos are inside the world too. All right, I mean, that's just to break the tension. That's just to break the tension. But there's a more serious situation. I mean, calm down, calm down. No, there's a lot at stake here, and I trust that, yes, and I trust that we all here understand the seriousness of what we're called here to do, and I trust that all.
1, 2.
You the hippo? I don't know. He came in front of me. I'm saying that I trust that what we're doing here during the course of this week will reach to the relevant directions. But there's a question I need to ask. To the best of your ability, because you said that there have been communications with the head of DC, etc. Are you of the view that there might have been communications with ministers of environment at any point in time?
Regarding?
Issues, challenges that are relating to our environment.
Yes.
Well, I would want to believe so.
Yes.
So why are we having the challenges that we're having?
Okay. So I actually have an answer for you. You asked why it is that we're not singing from the same hymn sheet. And I would argue, I would put to you that all of the rights that we enjoy today have only ever been gotten through the sort of legal action that you're decrying. Let me give you a very recent example. Very recently, an NGO, a regional NGO, brought a challenge against the buggery law in Antigua and Barbuda. And it was struck from the books because they succeeded in stating at the court level that it was unconstitutional. Universal adult suffrage in the United States for black people, that was a lawsuit. Revoking the Jim Crow laws, that was a lawsuit. Even down here, the labor unions were created. The right for a labor union to represent its workers, lawsuit. That's what's effective, that is what works. And if you have an example of what works, hoping for the goodwill of anybody, not just talking about the government, hoping for the goodwill of anybody to sing from the same hymn sheet as you, a developer is never going to sing from the same hymn sheet as an environmentalist, ever, because the developer talking money in dollars and cents. We talking about birds and fish. They don't care about birds and fish, they care about money. And if you have an example of something that works, use it. Hoping for the goodwill of people I don't think that has ever gotten us anywhere. Like my grandmother always used to say, closed mouths don't get fed. You have to open your mouth. And using the law is one way to open your mouth. So I would just put that to you to use what you have available. Hoping for goodwill and just, I want to protect the birds and the fishes and that's it. Hoping that that is going to be enough to advocate for the environment is not going to be enough. We're seeing that all over the world. We're seeing them wanting in the UK to open a coal mine in a protected area. In Germany, they want to do another Starling, another oil pipeline. We know about the environmental defenders in Alaska because they want to tear up their environment to do another oil pipeline. They're doing everything because just saying, oh, well, this is indigenous land. We are the rights holders. They don't care. So using what you have available to make them care is what you have to do. Arika, yes. Well, Nurse Wong had a question. Okay.
Oh, thank you. My hand was really getting tired. I just want my colleagues in the room to understand that advocacy is not an easy task. As part of an environmental awareness group in Antigua known as Alliance for Action, we have had the back and forth that Martin is speaking about, and we seem to be getting nowhere. We have been to all of the necessary agencies that you have quite well illuminated in your presentation. And as my colleague from Barbuda said, when you advocate, you are seen as a busybody. You're not only seen as a busybody, but you are marked. You are marked so that certain doors will not be open to you or members of your family. So singing from the same hymn sheet, that's a foreign language. As an NGO, I know most times when I name my NGO as Women Against Rape, people will say, well, what has Women Against Rape to do with the environment? But we need to understand that men and women are impacted differently by these kinds of socioeconomic and other conditions that prevail in our society. Our mood for this year is occupy and amplify. And I'm entreating my colleagues here, not those from the Department of Environment, the others. When you get invited to a consultation, go. Go to the consultation and make your representation. Last year, the Ministry of Foreign Affairs had a consultation, and a number of government agencies were absent. They weren't there. I mean, the environment comes under one of the SDGs. So if all the ministry is not doing anything, not saying anything, how will we move forward? And so inevitably, the burden rests on the shoulders of CSOs and NGOs. And I want people to understand we're volunteers, we don't get paid. We do not get paid. There are times when we may write a successful proposal, but you don't get a salary, you get a stipend to support parts of the work that you're doing. So I want again to encourage my colleagues from the NGOs. Let us come together as much as possible and see how we can work to alleviate some of the challenges that have been besetting us, not only recently, but for decades, so that we can move forward. I like the terminology you use for now and for the future, because there's some things that my second, third, and fourth generation, some of who were born here, would not know, would not see, because they have all been taken away from the landscape. So when you leave this meeting, go back to your groups and let them know what are the challenges. You may be facing some, you may not be facing some. And let us put our heads together. I know that all heads don't knock together. I understand for whatever reason, whether it's a color issue or any other issue, or you're not from your kind of issue. But the point is that we need to move forward. Thank you.
Thank you, Neswang.
Thank you very much, Aneka. I want us to give her a very big round of applause. I appreciate that you stood in the hot seat. She's on a sticky wicket. We appreciate it. We also recognize that we have another session that goes into what communities are doing, what people are doing in terms of advocacy, and Aneka will still be here. She'll facilitate that session. She's also here at lunch. Go talk to her, but give her time to rest and eat and okay. All right. So I want to thank you all. Thank you, Aneka. You may take your seat. We're now going to go to lunch. We get back at So we were supposed to, what time is the clinic, Sherelle? Oh, mercy. So we are very much over time. Guys, you're going to have to eat real fast. So our lunch time will be from 12:45 till 1:30 with the expectation that the clinic starts at 1:15. So if you have a clinic, your clinic will start at 1:15. So I'm going to ask the people who are going to be in the clinic to go get their lunch first, and everybody else kind of fall behind them. So the clinic starts at 1:15, and we'll see you back at 1:30, everybody. Thank you.
Just hold them and walk them.